You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. Welcome, Season 6. Great guest today, Geordan Logan, who I had the pleasure of meeting at the Outer Realm recently, which I'll let Geordan talk more about. Geordan is an indispensable member of Claggett and Sykes, working with Sean Claggett, Will Sykes, and just an incredible team out there that's working to change the landscape of the justice system, not only in Nevada, but beyond. And when I was out there, I got to see presentations from Geordan and from Sean Claggett, from Nick Rowley, from others. I was just blown away at some of the things that Geordan was teaching, especially on storytelling and visuals. So Geordan, welcome to the podcast.
Thanks for having me, Kenny. It's a pleasure to be here, and an honor to be here, and to talk to your audience about what I'm passionate about.
Awesome.
And to be quite honest with you, I am passionate about being a lawyer. I mean, it was kind of a calling of mine. From the time I was 8 years old, I knew that's what I wanted to be. I knew that's what I was meant to be, a lawyer. And then life just took me in all these different directions, and becoming a lawyer is now my third career. So at the age of 44, I was running Kaplan test prep for the Western United States. I was traveling 4 days a week, and I hated the job. So at 44, I came home and I said to my wife, I'm going to quit my job tomorrow and go to law school. And she kind of dropped her jaw, but she stood by. And I told her, I'm going to take a huge pay cut because I'll be starting at the bottom as a lawyer. And, I'm doing pretty well now. But I said, it's worth $100,000 a year to wake up in the morning and want to go to work. And that's what I'm looking for. And that 8-year-old kid, every time I looked in the mirror, he's pointing back at me and calling me a failure, no matter how successful I had become, because I wasn't a lawyer. So my wife, she thought at the end of the law school rainbow, there'd still be a big pot of gold. And so she stood by me. I graduated from law school, and I went to the public defender's office in Las Vegas, Nevada. I was a public defender in Sin City. And I got to tell you, that's the best job I've ever had in my life. It was absolutely an incredible job. I woke up every morning. I couldn't wait to get to work. I left at the end of every day and felt like I really helped somebody today. I felt like a lawyer every day, but there's no gold there. And then one day I was representing a city bus driver who shot a passenger on his bus, and Claggett and Sykes was representing the guy who got shot that was suing the bus company. So they came to court to see what was happening in the criminal case, and saw me arguing all my other criminal cases that day. And Will Sykes says to Christian Augustine, wow, that guy's really good. Who is that guy? And Christian says, oh, I went to law school with him. That's Geordan Logan. At the same time, Sean Claggett was riding the elevators at the courthouse and heard people on the elevator saying, did you hear that public defender this morning using Janis Joplin song lyrics in a sentencing argument? And Sean was like, who's that? And they said, oh, some public defender, Geordan Logan. So they started trying to recruit me. And I said, no, I love my job. I'll never leave my job. But ultimately, they made me an offer I couldn't refuse. And so I switched over to the plaintiff side, doing PI work. And it has been an incredible journey. And I'm really doing what I'm passionate about.
How long have you been at Claggett and Sykes?
So I started at Claggett Sykes in January of 2018. And when I started, Sean had his first 8-figure verdict. And then shortly after I started, he started another trial where he ultimately got an 8-figure verdict. And then I looked at the way they were doing things, the way they were presenting things, and I could understand the success. I could see where the success came from. But I had this burning desire to make it better because I felt that there were big holes in the way we were presenting information. One of my previous careers, I was in the Air Force for 9 years. And in the Air Force, I started in combat communications. So I deployed to Desert Shield, Desert Storm. And then after the war, I went to a leadership school and graduated as the top graduate. And the commandant asked me to come back to be an instructor at the school. So my last 5 years in the Air Force, I was an instructor of professional military education. And the school that the military puts you through to be an instructor was absolutely phenomenal. Like it really gave me this love of the way adults learn and remember things. And ever since then, and that was in 1992, I have been studying the way adults learn and remember things. When I got out of the Air Force, I went into the corporate world working for Kaplan. I was in the seminar business. I was doing seminars all around the country. I had people who were doing seminars working for me. And it always came back to the way adults learn and remember things. And when I became a lawyer, I stepped back and realized that of all the jobs we do as lawyers, writers and counselors and authors, negotiators, the most important job we have as a trial lawyer is that of a storyteller. And when we tell stories, the best way to do that is to remain focused on the way adults learn and remember things. And long ago, I learned that the secret is edutainment. You have to educate as you entertain. Because, and without getting into too much of the science, long ago, some educational psychologist named Benjamin Bloom, he came up with Bloom's taxonomy that talks about the levels of adult learning. You start at the lowest level, which is just knowledge, just being able to remember a simple fact.
Now,
Then, yep.
Jordan, people just listening on the podcast can't see it, but over your left shoulder, there appears to be a hierarchy. Is that from Bloom?
So if I flip that upside down, it could be from Bloom. It could,
Okay.
but it's actually a hierarchy of controls, of engineering controls. But
Okay. Got it. I
but
was just
flipped
curious.
upside down, that's exactly what Bloom's taxonomy would look like.
Okay, so
Yeah.
so so going back to Bloom's taxonomy, go ahead.
So the very, very bottom level is just knowledge, just remembering something. Above that is understanding. You can't understand something unless you can remember it. Above that is comprehension. And there's just this stacking level of the way adults learn. You can't get them to higher levels of adult learning, like synthesis or application, unless you can first get them to remember something. At the same time, a guy named David Krathwohl developed Krathwohl's taxonomy, which talks about the emotional taxonomy, that adults also require you to move them up the emotional taxonomy in order for them to move up the educational taxonomy. The lowest level is receiving. Somebody has to be willing to listen to you, to pay attention to you, in order for them to remember something. So when we go in and we do voir dire, and I talk to lawyers who are so frustrated that the jurors wouldn't talk to them, he couldn't get them to talk. That's kind of on us because we have to be focused on getting them to that first level in Krathwohl's taxonomy, being willing to communicate with us, to answer us. And then we can move them up the educational taxonomy at the same time as Krathwohl's taxonomy. This is me geeking out now, but it all comes down to
Geek out away. This is like geek out as far and as hard as you want to, man.
it all
We
comes down
love
to
this
the
stuff.
way adults learn and remember things is through edutainment. If something is boring, if it's blah, 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 no one's going to remember what you're talking about. And so, we'll talk a little bit later about my use of PowerPoint, which is an absolute requirement for us in openings, closings, rebuttals, witness examinations. We use PowerPoint all the time. It's important to the speaker to keep the speaker on track so that you're moving forward in the logical way that you had planned to, that you're not forgetting anything. But it's important for the listener too, because the listener's attention span is so short that you want to give them hooks. That's what I call them, hooks to the memories, to the things you're talking about, so that when they're back in the deliberation room, they remember your arguments because they'll remember something that was on the screen that you work in tandem with. They'll remember a picture or an image or a graphic or an animation, and that will remind them of your arguments about that picture, that graphic, that animation.
Jordan, question on that. When it comes to the number of images that you're using, the number of things that you're wanting jurors to remember, how do you make decisions on what goes in and what gets cut out in the sense of focusing jurors where you want them to focus, but also giving them enough to where if they missed 1 through 3, you still get them catching on 4 or something a little bit different for everybody. How do you draw that line in terms of how much to add and how much to take away?
That is a challenge. And when I was in law school, I used to say, I write better than anybody who writes faster than me. And anybody that I write faster than writes better than me. And I don't mean typing speed because I'm also a pretty slow typist, but the time it takes to think about the right words, the right sentence structure, the way of putting together the argument is where the bulk of my time in writing goes. And when I'm creating a PowerPoint, trying to tell my client's story, the bulk of my time goes into thinking about how I'm going to present that. And so when I talk to people and they look at PowerPoints, they're like, oh, how do you do that? Oh, I need to learn PowerPoint. And I try to back them away from that because it's not about PowerPoint. It's about your ability to tell your client's story. I tell people all the time, think Spielberg, not Bill Gates. Your job is to think about how do I present my client's story? Not about how do I use PowerPoint, because the thing about PowerPoint, I think in my mind, how do I want something to look? What do I want it to do? I know PowerPoint's got a way to do it. I got to figure that out. But the first most important thing is, what do I want it to do? What do I want it to look like? Googling how to do that is easy. Using the help system in PowerPoint, how do I do this? That's easy. But figuring out what you want it to do, how you want it to look, that's where the time should be spent. And I often tell people that adult memory, it all begins with a sensory input. You see something, you smell something, you taste something, you touch something. But if you're not paying attention to that sensory input, it never even gets into short-term memory. And if it doesn't get into short-term memory, it's never going to get into long-term memory. And so we, as the storytellers, are responsible for making sure people are paying attention to the sensory inputs that we want them to remember. So when you ask me, how do I decide what I put on the screen and where I put it on the screen, the thing with the biggest bang is going to be the thing that I need to grab their attention on. If I'm transitioning from one idea to another idea, I'm going to give them a brand new solid hook so that they can grab onto that memory and bring it back at any time.
And then, Jordan, going back to storytelling, just again,
Yeah.
big picture wise, and for instance, an opening, when you're making decisions on where to start the story or how to start the story, share with the audience your approach.
So every opening begins the same way for us. And while I don't believe that there's a formula that every case fits into, I do believe there's a structure that every case fits into. It's just like when you're building a house. Not all houses are the same, but every house begins with a foundation. And then you start building the walls. You start building the structure. So every opening we do begins with the first slide, that first intro slide, where we're telling the jury what the case is about. That slide is going to have an image on it, a graphic on it. It's going to have something on it that kind of subtly is driving home the bigger picture of what this case is about. It's really wasted space when you see people doing their openings and their first slide is just text that just says the caption of the case. When you think about it, the jury walks in, that's already on the screen. They're looking at it. They're sitting down. Everybody's getting ready. The judge says, plaintiff, are you prepared to give your opening? All this time, there's that billboard on the screen in front of them. To just have the caption on it is a real wasted opportunity. So we have an image on it that kind of subtly drives home the bigger picture of what this case is about. And there's no words on it yet. Then the judge says, plaintiff, are you prepared to give your opening? I stand up with my first click. And using PowerPoint, you really kind of time your PowerPoint with what you're saying. So as I say, good morning, ladies and gentlemen of the jury. This is the case of, click, now the caption comes out. I tell them the caption of the case. Then I say, this is a simple case, so you must be wondering why we're here. You think about this jury. They're a group of people who are living their lives, minding their own business, and they get a letter from the government that says, come down to this building and speak in front of a large group of strangers who are all going to be looking at you as you're speaking. Now, we know the greatest fear of Americans is public speaking. There have been studies that say Americans are more afraid of public speaking than of dying in fire. And yet the government is telling them, come down to this room, sit in this room, and talk about personal things with everybody staring at you. And if you don't show up, we're going to arrest you. So they're already nervous for being there. And then some of them feel like this is going to be a very important experience for them. It's their civic duty. They feel obligated. They feel proud to be on the jury. Some of them just get selected and they're like, oh, if I have to, I have to. Well, I want to start out in the very beginning telling them this is not going to be a hard job. This is going to be easy. This is a simple case. So let me tell you why. You must be wondering why we're here. Then I click, the next slide comes out, and this is one of the most difficult things to do in the opening. Let's come up with one sentence that sums up the whole case. In one simple question, what is this case about? Now, I've just told the jury, this is a simple case. You must be wondering why we're here. Then I click and I give them that one sentence. If it's not a simple sentence, now I've lost credibility with the jury. So that sentence may take me days to come up with and improve and change. And throughout the whole preparation of the opening, which may be 100 hours, I'm changing that one sentence to simplify it, to make it easier to understand. Do you see a blank white screen?
Yes.
Sure do.
All right. So, good morning, ladies and gentlemen of the jury. This is the case of Thunder Roybal versus Louis Bellomo versus Shack LLC. Now notice here, we've got the Las Vegas city skyline in the background, Sin City. That's where this case is taking place. Then when I clicked, that SUV drove across the screen and it's got the Sapphire logo on it. Sapphire is the world's largest gentleman's club, and it's here in Las Vegas. And it's got the driver, the chauffeur of the Sapphire Suburban, and he's looking behind him. And so this is what this whole case is really all about, right? It's about a professional driver who's driving for the world's largest gentleman's club who doesn't pay attention as he's driving. All of that is coming on the screen without me even saying a word. The jurors are just looking at this image and trying to figure out, what is this case about? And then I say, this is a simple case. So you must be wondering why we're here. This is an image of the courthouse that we're in that day doing the trial. You must be wondering why we're here. We are here because a professional driver, driven by impatience, hits a bicyclist and flees. That's the whole case in one sentence. A professional driver, driven by impatience, hits a bicyclist and flees.
And there's something on the screen for folks who are listening, and we encourage everyone to go to the YouTube channel and watch this. It's excellent. On the driven by impatience portion of the screen, there's a yield, but under the yield sign, it says to no one.
And now I got to tell you, like we do a lot of work with lawyers all around the country, and we create openings for them as a part of our consulting. And I will give them something like this, and they will be resistant to it because they're afraid of an image like that, yield to no one. And they say, oh, we'll never get away with that in our court. You got to try. Like, I think to be a good trial lawyer, you have to be bold, you have to be confident, and you have to be prepared. And so before we do an opening, we give the defense all of the images in our PowerPoint. Just the images. I'll take all of the images from my PowerPoint and I'll put them into a separate document, jumbled up, not in the order I'm presenting them, and I don't give them any of my words. I just give them the images. The words are my work product. If they want to see my PowerPoint, then they need to show me their opening. And a lot of defense attorneys are still doing openings from a yellow legal pad, a written out opening. If they want to see my PowerPoint, they need to show me their legal pad with their opening on it, because my words are my work product. So a lot of lawyers we work with, they're afraid to go to court and kind of make that argument. But you would be shocked at how often stuff like this I get in at trial because either the defense attorney doesn't object to it, or he does, and then I talk to the judge, and it's up to the judge. Defense attorneys, by and large, are going to object to everything. They're not going to allow you to get anything in. But it's not up to them. It's up to the judge. So if they object to images, I'll say, okay, well, let's talk to the judge about it. And then I will have a strong, well put together argument ready to talk to the judge about why this should come in.
Yeah,
This is a separate. Yep.
and Jordan, I was highlighting because I liked it. I mean, it was
Yeah.
because it was subtle.
Right.
I mean, it was subtle, and it was, oh, there's a yield sign, and it may have been my subconscious that noticed it first. And then it's like, yeah, this guy's impatient, yields to no one, hits the person, flees. And I think the nice part, I remember looking at that slide when we were in California together. And when I saw that, I think kind of for me, like determining whether or not quote lands is at the end of the slide, if I can say, all right, I got it. And here, when I look at it, I'm like, oh yeah, I got it. Okay. It's like, all right, got it.
It's so
I'm
think
not
about
having
that.
to
Like
question
you,
things. I've got a really good feel. And, when the other side gets up and tries to argue, what are they going to say? The guy wasn't a professional driver, that he was a bit patient, that he didn't hit the bicyclist, that he didn't flee. I mean, that's a tough box you put him in.
yeah. And think about like what you just experienced is very much like a juror seeing this for the first time. So where you kind of just subliminally notice, yield to no one, that's the same thing that's happening to the jurors as they're watching this. And I'm giving them, a presentation that is on point. I don't talk about things that aren't on the slide. We're only talking about what's on the slide. They're going to remember this sentence because of the images I've attached to the words of importance. Those are the hooks that they're going to remember what happened in this case. And also, there's been a lot of studies over the years into how adults learn, how adults remember things, and how adults make decisions. And so I call these seeds of alignment, where I start passing words to the jurors in opening or even in voir dire to kind of set up who the characters are and to set up the story as we get into it later in the trial. So I want the jury to know from the very, very beginning that the guy who hit my client was not just some knucklehead behind the wheel. No, he's a professional driver. I'm telling them from the get-go, this was a professional driver. I don't just say a guy driving for Sapphire's Gentlemen's Club, because that's not what's important. What's important is he's a professional driver. He should know better. I want very early on to label his behavior as impatience, because when I watched this guy's depo, I just came in to do this trial. I didn't do the litigation for this. And so when I watch his depo, this guy looks like an impatient guy. He looks like the kind of guy that just flies off the seat of his pants and he yells and he screams and he
This
makes
this
shit
was the
up.
this was the actor.
Yes, yes. So this entire my adverse direct to him is on CVN, and it's one of the most enjoyable crosses directs I've ever done. And you should, if you get a chance to see it on CBN, it's in the Thunder Roybal case, and his name was Louis Bellomo, and it's just it's a pleasure to watch.
Jordan, tying those 2 points together, when did y'all call Mr. Bellamo as a witness?
So I believe that you've just done voir dire, you've built a rapport with the jury, and then the defense attorney stands up and he tries to build a rapport, and usually they're not good at that. And then I get to stand up and give the opening, the first opportunity to talk about the case, to frame it, I've already told them it's a simple case. So I want my first witness to be somebody who's not going to take any shots, somebody who's going to be solid, who the defense isn't going to be able to cross them and weaken their position. And if they can kind of set up the whole story for me, then it's a great witness. It is rarely, if ever, my client, and it is rarely the defendant, although sometimes it is. In this case, we put Bellamo in after police officers talked about his conduct, witnesses talked about what they saw at the scene. We wanted the jury to have some understanding so that when he got in and started all his lies, they already had a setup for those lies. So he was somewhere in the middle, towards the end of our case in chief, actually.
Yeah, I like that because then it's not Jordan versus Bellamo. It's, hey, you've heard layer after layer after layer, and then you get this guy again going back to seeds of alignment. Um, Everyone's kind of rowing in one direction, and then you get, this guy trying to say everything that everyone has said and everything you've come to believe to this point is wrong. And, believe me,
Right.
Mr. Bellamo, the hit and run professional driver.
Yeah. And that's another one of my theories about when you're doing openings is to the jury, we are lawyers who a lot of jurors think that lawyers will say anything to win their case, that they'll just manipulate the words of witnesses, that they'll change the way they present facts so that they can win their case. And they look at that as kind of a negative thing. And so anytime I say something that's important to the jury, I want to show them something. If I say something, I show it to them. Where did I get this information from? Because now, as soon as I sit down and the defense attorney gets up and they just start blah, 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 making all these promises, but they're not showing anything to back up what they're saying. I want the jurors to know in opening, this fact that I'm telling you is so important. Here's where I got it in this document right here, in this exhibit right here, from this witness right here. So that when they see it during the trial, they get it. Oh, yeah, that is true. You've told us about this.
Excellent. Excellent. So we've got why we're here. Where do you go from
Yeah.
there?
So the first thing, every case is the same thing. We start with a powerful opening slide. Good morning, ladies and gentlemen of the jury. This is the case of the caption. This is a simple case. You must be wondering why we're here. One sentence to sum up the entire case. Simple sentence. And then we go into timelines, like the incident itself, what happened in the incident. More than likely, in a case where we're trying to show the system failure, there's going to be a timeline before the incident timeline, which is places where this incident could have been prevented had they been paying attention, had they cared. So in the professional driver case with Louis Bellamo, we also did another case where we had a driver of a garbage truck who ran over an 11-year-old girl in an intersection. In both of those cases, we had a whole history of their pre-incident driving failures, speeding tickets, crashes, driving without insurance, all of these other things where if these companies were paying attention, they could have buckled down on these guys. They could have put them through additional training. They could have let them go. In fact, in the garbage truck case, it got to the point there were so many collisions and infractions and problems that they did ultimately let him go. And then there was a union grievance and they bring him back. But when they bring him back, what they decide to do is he was on a commercial route picking up dumpsters from behind businesses and he kept crashing into things. So when they bring him back, they say, let's put him in a residential neighborhood around schools. We know he's a dangerous driver. What harm can he do in a residential neighborhood around schools? And so sure enough, when he runs over our young girl in an intersection where she had the walk sign, he was within a mile of 3 schools all around. She was walking home from a middle school. There was an elementary school 2 blocks away, a high school half a mile away. And,
Hey, Jordan, one thing that I want to make sure we talk about, because I fell into this trap um, as a young lawyer and I want to help others avoid it, is all this magic that you're creating in a courtroom at trial, it didn't start a week before the trial or 2 weeks before the trial or 3 weeks before the trial. I mean, will you speak to just the work that goes in to gathering the evidence, identifying the witnesses, having the pieces to be able to tell the story? I mean, it's kind of like Spielberg, right? Like if you're going to create a great film, you need to have so many other pieces in place before the scene begins. So can you speak just to the amount of work? Because I don't want anyone to be misled into believing that if you just have, some understanding that the evidence suddenly or magically appears before you.
Yeah, oh, it's a ton of work. It is a ton of work. And I put more time into the opening than I put into any other part of the trial because it's not that I believe that you win or lose in the opening, but the opening is the entire case. And so when I'm finished with an opening, I like to say that's the whole case wrapped up with a bow on top. Now all I have to do is prove what I said in the opening. So the opening is the roadmap for what needs to be proven in this case. And these are the things I've promised the jury. This is what the evidence will show. So now my job in the trial is just simply to prove what I said in the opening. That's why the opening takes so much time, because it's the whole trial. And I've heard a lot of people say that you win or lose in the opening itself. And I don't agree with that because I think you can fix problems that came up in opening, but you're starting from behind the line. So if you get the opening right, then you're probably going to, and you go about trial just proving what you did in the opening, you're going to find some level of success. So the way we do it is we put everything into what we call worksheets. And so I developed these worksheets long ago, and there's a witness worksheet because you got to know who the characters are in the story you're going to tell. We tell the story through the characters. So you have to define who the characters are. And on that witness worksheet, I want to know what the must-gets are. What is the thing that I need to get out of this witness before they get off the stand? We want witnesses on the stand only as long as necessary to get the must-gets. Get them up, get the gold, get them gone. That's my thought process on every witness. And the gold is the must-get items, the things that this witness must say, or the pieces of evidence I must get in through this witness before they get off the stand. Then after the witness worksheet, we have the timeline worksheet, and the timeline worksheet breaks out like all of the data points that make up this case from before the incident to the incident itself to after the incident. Then we have the damages worksheet. What was taken from this client? What do we have to ask the jury to consider in order to make my client whole? And then we have what we call the alibi worksheet, which is so important. It's in every opening we do. It's the alibis, the defenses, the excuses. After I've told the whole story of what happened in this case, including the damages, I now look at the jury and I say, so what do the defendants have to say about all of this? And then I go into their alibis. First, you'll hear that they are not responsible because. And then these don't have to be what I think the defense is going to say, but it's all of the things in my case that make me nervous. The things in my case that I think I will lose or my damages will be lessened because of this fact. I'm going first. I get to frame that fact. I get to set it up. And so I'm going to talk about it before the defense is going to talk about it, but I'm going to frame it in such a way that it either works in my favor or it lessens the blow. And so sometimes I don't even think the defense will actually say it. Like we did a trial in Portland, Oregon. Guy was like 41 years old. He went in for a routine colonoscopy and they killed him. Now, he was a big
Who killed him?
man.
The anesthesiologist killed him.
Yes, that's
Ugh.
right. Yeah.
All right.
So he was a big man, tall and a little heavy. And I was a little nervous they were going to talk about his comorbidities, that he had high blood pressure, and they were going to talk about, he wasn't real healthy. And then the jurors were going to see a picture of him and they were going to blame him in some way. That made me a little bit nervous. So one of the alibis I made is we are not responsible for Eric's death because he lived an unhealthy lifestyle. And then we went about undermining that and framing it the way we wanted it framed. They knew about all of his comorbidities, and yet they still did what they did anyway. They knew that this provided a higher risk, yet they didn't account for that risk. Then we finish our opening. Defense attorney gets up to give her opening. First words out of her mouth. Well, I would never say anything like that. His health and his weight had nothing whatsoever to do with what happened here. Great. Thank you. Now that's off the table. Now the juries aren't even going to think about it. Now the jurors, when they go back to the deliberation and somebody says, well, he was kind of a big guy. Yeah, but even the defense attorney said that had nothing to do with what happened here. So while I didn't think she would actually say in her opening, we're not responsible because he was a heavyset guy, I was worried that the jurors may go there, they may think about it. So I had to undermine it. Most of the alibis, though, are the nonsense you expect they're going to say. This is why they're not responsible. And I take whatever that reason is, and I make it a little bit ridiculous, and I really widen the net. So however they say it, I capture it. And then however they do say it, the jurors are going to be like, oh yeah, Mr. Logan told us about that one. That's that ridiculous one. However they say it, they think about the way I framed it first. And so it's a huge part of every opening we do.
I love it. And Jordan, during the case, do you ever refer to this or to these as alibis?
We do. Yeah, we do. We absolutely do. In fact, on that slide, it says alibi number 1, alibi number 2. And then after we undermine it, we go back to that first thing, their alibi, the first slide, and we cross it out. So we go through each of the alibis, we undermine them, and then we cross them out.
Out of
And we
curiosity,
tell the jury,
when y'all put up alibi, what color are y'all putting alibi in, and then what color are y'all putting the X out in?
so the word alibi 1 is in red, and then the statement we are not responsible for is in black, and then their actual excuse comes out in red again. But then the rest of the slide is all white on the background, and then it's a big red X that ultimately crosses off the whole slide.
Nice.
Yeah.
So I was just looking at something. My wife sent me something this morning. It was talking about the use of color by Vince Gilligan in the show Pluribus right now. And something that in film, and you're probably aware of this, they talk about the 60-30-10 with the 3 colors and the 10%. I think it's probably why I noticed the yellow in the Why We're Here.
Yeah.
But the 10%, the 30%, the 10% is like the accent, the 30% is kind of what you're seeing, the 60% is falling into the background. It was a neat concept that my wife just happened to send me, and so I was curious about. I had a feeling that it was going to be 3 colors that were in the slide, the white being the
Yeah.
background, the red, and then the black accent. So, anyways,
Yeah. Well, I've got to look into that. Now that you've piqued my interest on it, I got to go geek out on it and learn whatever I can.
so growing up, like again, I always thought doctor, lawyer, doctor, lawyer, doctor, lawyer. It's kind of what I got taught.
Yeah.
My dad was born shortly after the Depression. His family had lost everything by the time he was born. And it was, hey, if the world goes, then the things to be are a doctor or a lawyer. And that's
Yeah.
pretty much what I decided I was going to be. And I wasn't good at ninth grade biology, which I've talked about on the podcast before. So it was like, well, I guess I'll be a lawyer and being a lawyer fit. Um, there was a moment in time, though, where I really flirted hard with the idea of going to film school. But at the time, a place called Emerson College in Boston was like, I think 30 grand at the time. I don't know how much it is now. Or I could go to get paid to go to school.
Right.
So I went the law school route, but there's still that when you talk about like more Spielberg than Gates, it's like, oh yes, say more.
Yeah.
Um,
Yeah.
man, this is awesome. All right. We've got some time before we run out of time though. I want to talk about Outer Realm. You've got the Outer Realm hat on. That's where we met, where again you did just some incredible presentations, some of the things that we've talked about today. But share with us what the outer realm is?
So the Outer Realm is a group of lawyers from around the country who believe in what we're doing, which is giving the consumer, giving the general public a road, an avenue, a place to go to find justice when they've been wronged. And the thing that the Outer Realm is really focused on is sharing information with other like-minded lawyers. So other plaintiffs' attorneys who, regardless of what state they're in, we want to help them to succeed because our goal is really the Seventh Amendment, the right of the people to have a civil lawsuit and to find justice. And, we found that there are a lot of organizations of attorneys where they come together and they only share information very insularly, just amongst themselves. They don't get it out to everybody. But we all believe that when the tide rises, all boats rise, and so we want to help everybody to get better. And then a part of that means that lawyers in the Outer Realm are committed to contributing 3% of their fee to helping social justice causes, helping to shape judicial races around the country. And so when we hear about, in some states where judges are elected, we sometimes wind up with judges who don't have a lot of trial experience, don't really understand the things that we need to happen for a fair trial. And we get horrible rulings and our clients get cheated. And so we participate in judicial races all across the country because all we're looking for is a judge that gives us a fair opportunity to present our side of the story and defense to present their side of the story. We want the jury to sit there and decide after hearing two truthful stories where the truth really lies. And so the Outer Realm is a group of attorneys who are committed to that, committed to social justice, social causes, regardless of where they're happening in the country, and protecting the Seventh Amendment.
Yeah, thank you. And Sean and I talked, I think the night that Outer Realm ended and maybe the next day as well. And we were talking about the absence of meaningful voir dire in South Carolina. It's not as a matter of law, it's as a matter of custom. It's the judge's discretion, but again, as a matter of custom, attorney participation in voir dire here is minimal and honestly pretty meaningless. So I was saying, hey, Sean, here's what we need. And immediately I'd talked to John and Alicia Campbell before. We'd done cases together before, but really engaging their help and the help of some of their research team, the folks at Cornell and so forth. Alicia and I ended up on a hour-long call last week, and I said, look, we don't want voir dire here simply to get better plaintiffs' verdicts. There are counties here, if I'm being honest, there are venues in South Carolina where as a defense or as a defendant or defense lawyer, man, it's going to be tough to get a fair trial for those folks. That's not right. I mean, that's not any more fair and just in that setting than it is if we're getting beat up in a place where it's harder for the plaintiff to get a fair trial. So it's like, God, wouldn't it be nice to actually know these things about our jurors? I mean, we were picking a jury a couple weeks ago in a case that settled right before openings, but as we're picking the jury, judges, is asking these questions I'd submitted, and I'd made the motion for attorney participation in voir dire that got denied, and there were a series of questions that we submitted, and he said, well, I mean, Mr. Berger, why is it you want to know the answer to this question? I just said, well, Your Honor, I mean, what's the harm in us knowing? He was like, well, that's fair. Okay, I'll ask it. And that's kind of my point. It's like, what in the world is the harm of actually knowing more about our
Right.
potential jurors? And what I said was, look, not for purposes of cause challenges, but simply to exercise peremptory challenges. I mean,
That's
our
right.
peremptory strikes, we've had this case for a long time. Defense counsel knows this case. We know this case. It would be a benefit to them to know the answer to these questions. It would be a benefit to our client. And it's simple, and we can do it quickly. Um, And so again, going back to the outer realm, one thing that came of this is hopefully additional support from national figures to help us get meaningful voir dire in South Carolina. Again, not just so that plaintiffs can get a fair trial, but so defendants can get a fair trial too, for God's sakes.
Absolutely. In fact, one of the other things we do in every opening is we have a section called the job of the jury. And we tell the jury that their job is to investigate what happened here, why it happened. And we end with saying, ultimately, your job is to search for the truth. And we do trials all over the country, and in just about every jurisdiction, there is a jury instruction that says the purpose of the trial is to search for the truth. That's what it's about. So it's not about, we're not looking for judges that weigh it heavily on the plaintiff's side, because that's not a search for the truth. We want the jury to sit there and hear what really happened in this case and why it happened and make a fair determination of what was taken from our client. Big verdicts don't come from biased jurors who lean in favor of the plaintiff only. Like, it comes from jurors who understand what really happened in this case, and they truly believe this shouldn't happen in our community. Stuff like this shouldn't happen in our community. And then they send a message to those defendants why their conduct was so egregious.
Jordan, last question, I believe, for me, when in the storytelling, the demonstrative, the PowerPoint of showing jurors, again, we've shown how valuable these assets, these items, these parts of life were to our client. And we've talked about how they've been taken. We've talked about how they've been damaged through the negligence or recklessness of someone with no right to do these things, and no fault of our client. When you're getting to then putting dollar figures on these damages, what are you doing from a visual standpoint to help tell that part of the story?
So that is a struggle too. That is definitely a struggle. We rarely put in medical records or put in the medical bills. But certainly, like in a medical malpractice case where we have a large life care plan, that life care plan, I don't get into the minutia on anything in the opening, but it's the big picture of this is what this client is going to have to live with for the rest of their life. And then we talk about the cost of that. So I have done things where, like, if a client has had a lot of treatment, I'll show bird's eye view of like the months of the year with all of the doctor appointments colored in a different color for the type of doctor it is. And then what we're trying to do is make the point of going to the doctor has become my client's job. This is day after day going to the doctor. They wake up in the morning, which doctor do I have to see today? It becomes a full-time job just managing their care. And then when you see kind of big picture of across the year, how many appointments they've been going to of all these different types of doctors, that kind of lessens that argument that the defense is going to make. Oh, they're just doing this for money. This is just a money grab. Well, if you're working that much for this money grab, that's excessive. Like, they get it, that it couldn't just be somebody making up their pain if it consumes so much of their life. When we have wrongful death cases, one of the things that I've done, so in the outer realm, I gave this speech where I talked about when you present your client's story, you have to present it in a way where you make that connection, that human connection of how it's impacted their life, the life of their loved ones. You have to present it in a way that the jurors understand that kind of impact. And when you do that, it raises oxytocin levels in the blood system, in the brain. And this professor, Professor Paul Zak, he's like one of the top cited scientists in the world. He did a study where he had people come in, took their blood, measured their oxytocin levels, then told them a story. Half of the group heard just kind of a story that ended kind of on a positive note, not really positive, not really negative, just kind of ended, took the boy to the zoo, the boy had cancer. They went to the zoo and had a great day at the zoo. The other half of the group heard about how this boy is dying and his father knows he's dying, but the boy doesn't. And every day when the father interacts with the boy, he has to be strong so that the boy doesn't know that the dad is sad because his son is dying. And then they measured the blood of both of the participants afterwards. And the participants that heard that story about connecting to the human emotions, the human experience, their oxytocin levels spiked. And after that, he says to both groups, you all have an opportunity of donating the $100 you were paid to be here today to a group for childhood cancer. When he looked at the results, the group of people whose oxytocin levels increased dramatically, they donated most of the money they were given. Some donated the entire amount. So there was a correlation between how much their oxytocin levels spiked versus how much money they gave. And so the point was that when human beings are making decisions, some of it is biology. It's if you tell a story in a way that you can touch them, where they can feel the human experience in the story, they're going to tend to, oxytocin is known as the love hormone. It's the trust hormone. They're going to trust you more. They're going to believe in your story more. They're going to believe in your client more. And that's where bigger verdicts come from. And so it's not enough just to say, my client has the following damages. My client's life will be shortened by this many years. But to tell it in a human way, like when my client died, his daughter was 16. 1 year later, she graduated from high school and he wasn't there. 2 years after that, she got engaged and then married and he wasn't there. When you talk about the things that truly were taken from him in a human level, rather than just he lost 4 years, 5 years, 10 years from his life, oxytocin levels go up, the jurors trust you more, they believe in the case more, and higher verdicts are the result.
Yeah. Thank you, Jordan. And you've just been fantastic. Y'all are handling cases all over the country. For folks who want to get in touch with you, what's the best way for them to do that?
So our website is claggettlaw.com. That's CLAGGETT law.com. My email address is glogan@claggettlaw.com. Feel free to reach out to me, or you can get to us on our website. But we assist with cases all over the country. And again, we believe in sharing the information so that all of us find justice in whatever jurisdiction we're in.
Now, you guys are the real deal, man. Y'all have done the work. And I remember Sean all the way back in like the early reptile days when I was a baby lawyer, and the amount of work that he and Will and Matt and you and everyone at y'all's firm has put in to become one of the preeminent law firms in the country is just can't be understated. So congrats on y'all's success. It was very, very well earned, and look forward to what comes next with you guys, and look forward to being part of that outer realm that works to protect all those that live within it.
All right. Well, thanks for having me on. It was a lot of fun. I look forward to seeing you again in the future.
I do as well. Ladies and gentlemen, our guest today has been Geordan Logan of Claggett Sykes. Just a great lawyer, great person. And thank y'all so much for being with us today. We look forward to doing it again soon. Take care. Thanks for listening to Best Practices with Kenny Berger. This podcast is produced by my law office. We are a trial firm based in South Carolina, focused on life-changing injury and wrongful death cases. Here's the deal. If you find these conversations useful, if you think they've benefited you or might help somebody else, please follow the show and share it with other trial lawyers who might appreciate it. Lastly, thank you so much for listening, and we look forward to seeing you next time. Take care.